Hello, and welcome to Jurist, Conversations in Law. I'm Kristen and Boon, the Susan and Perry DeLeese Dean of the Common Law section at the University of Ottawa's Faculty of Law. This podcast is a space where we explore some of the most pressing legal questions of our time through thoughtful conversations with scholars, practitioners, and judicial leaders who are shaping the law and its role in society. Today's episode takes us into a foundational area of law, freedom of expression. In recent years, we've seen renewed debates about the scope and limits of free speech. These conversations are unfolding in courtrooms, on university campuses, across social media platforms, and within our broader public discourse. They raise complex and sometimes uncomfortable questions. How do we balance freedom of expression with other fundamental values like equality, dignity, and safety? Who decides when speech crosses the line? What role should governments, institutions, and individuals play in shaping the boundaries of open debate? I was delighted to have a truly distinguished guest visit the University of Ottawa's Faculty of Law recently to help us navigate these questions. Nadine Strossen is Professor Emerita of New York Law School. She is also the former president of the American Civil Liberties Union, where she served from 1991 to 2008. The longest tenure in the organization's history. Throughout her career, she has been a leading voice in civil liberties and human rights, and she currently serves as a senior fellow with the Foundation for Individual Rights and Expression, or FIRE. Professor Strossen has spent decades at the forefront of debates about free speech, advocating for robust protections while engaging deeply with the tensions that arise in diverse and democratic societies. Her work challenges us to think critically about the role of open dialogue, the risks of censorship, and the responsibilities that come with expressive freedom. In this conversation, we explore the evolving landscape of free expression, from the concept of the marketplace of ideas to the realities of digital platforms, political polarization, and shifting norms. We also reflect on the essential role that lawyers, legal institutions, and civil society play in ensuring that rights are not only recognized on paper, but meaningfully protected in practice. I really enjoyed this conversation with Nadine. In our preparation, she said to me, "Kristen, you can ask me anything." This is a conversation that speaks directly to anyone interested in the future of democratic engagement. I hope you enjoy it. Well, Nadine, welcome to the University of Ottawa. It's great to have you here.
Thank you so much, Kristen. If I can just respond to this gracious greeting in kind. First of all, I have deep respect for your campus. I am wearing your color. And I want to also say that I am so pleasantly surprised to have such a wonderful turnout.
So let me open with a personal question. You have dedicated your life to freedom of speech. What has motivated you to do this?
I actually would describe myself as a lifelong civil libertarian and human rights advocate, culminating with my almost 20 years as president of the American Civil Liberties Union, ACLU, which is the oldest and largest civil liberties organization in the world. And I've also been very active and on the executive committee of Human Rights Watch, which is the major US-based international human rights organization. And the agenda for both of those organizations, to which I completely and wholeheartedly subscribe, is full and equal civil liberties, fundamental freedoms, and human rights for everybody, no matter who you are, no matter what you believe. By virtue of your humanity, you are entitled to these fundamental freedoms. However, starting about 12 years ago, I began to perceive that freedom of speech and associated freedoms, including academic freedom, were increasingly under attack from both ends of the political spectrum in the United States as well as around the rest of the world. And I saw the situation as being so dire that I made a determination that I would concentrate specifically on that aspect of human rights and civil liberties, because I believe that free speech is somehow more important than any of the other rights. I remain passionately committed to privacy and equality and fundamental fairness and human dignity, and the list goes on of many specific aspects of human rights. But I remain convinced. I always say remain because I'm open-minded, so try to dissuade me. But so far, I remain convinced, based on my own now extensive experience, based on the study of history, based on examination of what's going on around the world, that freedom of speech is the essential foundation of every single other freedom, of every aspect of the human rights agenda. And conversely, that censorship, unjustified restrictions of speech are the single greatest impediment to every other human right. So with all due respect, I would say, because of my lifelong commitment to human rights, I have decided to focus on freedom of speech.
You're known as an ardent defender of the marketplace of ideas. And I'm just wondering if you can sketch out what those principles are, and also explain whether you see there being limits on the marketplace of ideas.
Yes, Kristen, if you look at the actual language from Supreme Court Justice Oliver Wendell Holmes, who coined that phrase, he's making a rather modest claim, which is that the marketplace of ideas and the free exchange of ideas and debate and discussion is more likely to lead to truth than centralized control and gatekeeping by government or by any other centralized authority. So the phrase that he uses is better. It is better designed. And I think tied up with that, Kristen, it's absolutely true that freedom of speech in the marketplace of ideas may, certainly in the short run, maybe even in the long run, lead to many false and dangerous and misleading and evil and harmful ideas. But the question is, as compared to what? Would we rather trust government censors? And I say that in a completely, nonpartisan way. I don't want Donald Trump acting as censor, but quite frankly, I wouldn't want Joe Biden or, Mark Carney or anybody else acting as government censor. I keep thinking of that famous metaphor that Winston Churchill had about democracy, and I'll say that about free speech and the marketplace of ideas. It's the worst alternative except for all of the others. Mm-hmm.
So maybe I can invite you to take that one step further and tell us a little bit about what you see happening in the United States right now. We watch with great interest what's happening south of the border. A little later on our conversation, I'd like to go specifically to university campuses. Mm-hmm. Could you tell us what's happening?
It is a very interesting time, as the ancient Chinese curse puts it. Where I talk about free speech probably about 5 times a week at least, and no two conversations are alike because there is a constant evolution of developments at the national level, at the local level, the international level, government, social media, peer pressure, all of the sensorial forces, and with different kinds of incidents. So if I were to crystallize a very complex welter of facts and law, I would say that we have sensorial forces from, again, all across the political spectrum, that we continue to see what is often described as the common belief in freedom of speech for me, but not for thee. And the only difference between the left and the right, one party or another party, is exactly which speech and speakers are the most dangerous and which should be restricted. If I can jump ahead, Kristen, you asked me a general question
Yeah.
about the state of free speech. There are so many assaults on free speech now that to keep up with them is almost impossible. But when I am asked, as I regularly am, of all of those assaults on free speech, which one do you consider the most dangerous? To me, that is sadly an easy answer. And that is the assault on lawyers and law firms. Because without lawyers, without those who advocate for free speech, who represent those whose free speech is threatened, we don't have meaningful freedom of speech. And I really fear that the intimidation that we are seeing of the legal profession, it's more than fear, Kristen. I can observe and report that lawyers and law firms who used to do work for the ACLU and for other civil rights and civil liberties organizations aren't doing it because they are afraid that the Trump administration is going to deny security clearances, even deny access to federal courts, as has happened. And even though the law firms who resisted and went to court have won in court, the damage is still done, right? Because who wants to have to go to court and expend all of those resources and all of that time? So, on the other hand, there are lawyers and law firms who are courageously standing up and speaking up and advocating positions that are inconsistent with the Trump administration's policies. And we are so indebted, I'm going to say to you, because I really hope that each and every one of you will take seriously the responsibility and the privilege of the wonderful education you're getting here and understand that you make the difference between the rights that exist on paper in your charter of rights and freedom and whether they actually are enjoyed as meaningful rights.
I want to bring in a question from the audience. Who should be responsible for establishing restrictions on freedom of speech for the protection of others?
Well, in a democratic society, certainly the government should. And let me give you a counter intuitive understanding that I really became aware of after the terrible events of October 7th, 2023, and the aftermath with too much misery and killing on both sides. What I saw on campuses in the US convinced me, you said you wanted to talk about campuses, that to have meaningful enjoyment of free speech, of course, it is essential that government, including public universities, not impose unjustified restrictions on free speech. But what really became clear to me for the first time, Kristen, was that it is equally important that government, including public universities, do not allow speech that is not justifiably protected. Speech that constitutes harassment or intimidation or threats or intentional incitement of imminent violence, none of which is protected, even under US free speech law. And why? Because if you are subject to that kind of expression as a target of threatening or intimidating or harassing expression, you are going to be chilled in exercising your free speech rights, not to mention enjoying your privacy and freedom. So government has a responsibility to enforce the law, not only against physical assaults, but also against expression that is justifiably unprotected because of its silencing and other concrete negative impact on other people. And I do think in a society, what is often called cancel culture is maybe taken to an excess of something that we all should do. We all have a responsibility to conscientiously and respectfully exercise our own free speech rights, to engage in a constructive manner with others. And that means that we should self-censor. The fact that you have the right to say something doesn't mean that it is right to do it. And freedom of speech includes the freedom of choice, both to choose what to say and to choose what not to say. And we should use our free speech rights to strongly criticize views that we think are misguided or evil or dangerous. But hopefully we will do that in a proportionate way, not seeking to completely cancel the person or exile them from polite society. And hopefully we'll do it in a strategic way, because if you are, just heaping scorn upon somebody, that is unlikely to change their views. But if you think that they're misguided, but if you engage with them in a respectful manner, there are just so many powerful examples of people, even who had been leaders of hateful, discriminatory organizations, who recanted and repudiated their views. And it's never because they were imprisoned or shamed and shunned and ostracized. It's because of patient engagement with other people who respected them as people, even disrespecting their ideas, and engaged with persuasion rather than shaming. And again, you're all lawyers. This is the art of advocacy and persuasion.
Mhm. I wanted to go back to something that you said a few minutes ago, which is that you're noticing this censorship, cancel culture from across the political spectrum, and I'm wondering if you can lay out for us what you see the balancing act to be between diversity, equity, and inclusion, and other movements that are very important in society and free speech.
Yeah, to me, Kristen, and this kind of goes back to my answer to your excellent first question, these are mutually reinforcing and even synonyms for each other. The values of diversity, equity, and inclusion obviously can be subject to interpretation by each of us, but I interpret those concepts completely consistently with the concept of full and equal human rights that I mentioned earlier. So we should have a diversity and equity and inclusivity, not only on campus, but in society at large, that fully embraces and respects and welcomes and empowers all individuals, no matter who they are and no matter what they believe. So to me, this is a concept that should embrace not only DEI among identities, which is the way it tends to be emphasized or has tended to be emphasized in the United States, but also among ideas, religious beliefs, philosophical beliefs, and so forth. And as with all ideas that are positive or at least have a positive potential, they can be distorted, they can be enforced in a way that some of us consider to be inconsistent.
I'd like to move the conversation now to online issues and social media, and also pick up on a question that came in from the audience. Is there a difference between free speech online and offline? And what are you seeing in particular about algorithms, which seem to advance violence and extremism? Someone in the audience noted that they saw a video where Toronto police went to a woman's home and threatened to arrest her for something that she had posted on Instagram.
My view is, and much more importantly, the view of the United States Supreme Court unanimously across very deep ideological divisions, is that the very same free speech principles that have applied to all other media should apply to the online media. That doesn't mean that the result will necessarily be the same, but you use the same standards. And I know you have very similar standards in your system of law and internationally and in many other countries. It's essentially that no freedom, including freedom of speech, is absolute, but the government bears the burden of proof to justify the restriction. I know you recently had a big case here about the emergency power, and so raising exactly similar concepts. Our burden of proof is that the government has to show that a restriction on a fundamental right, such as free speech, is narrowly tailored to promote a countervailing goal of compelling importance, which certainly children's welfare, which is usually advanced as a justification for restricting social media, the health and safety of other members of society, certainly interests of compelling importance. But the difficult question, the hard issue for the government to show, is that the restriction is not only narrowly tailored and actually does materially promote what's often just asserted or assumed will be the countervailing benefit, but also that it is the least speech restrictive alternative. And when you think about that, that's just common sense, right? Why should we give up freedom of speech unless we do get some benefit in return? And why should we give up as much freedom of speech if we could get the same benefit without giving up so much freedom of speech? What I would wish for is that there would be more choice for those of us on the user end. And in the digital rights sphere for a couple of decades now, there's been something we advocated. The principal author was the Electronic Frontier Foundation, EFF, which is very strong in Canada and the US and many other countries. ACLU and other digital rights groups have advocated something called the Santa Clara Principles, which, among other things, would call for complete, radical transparency on the part of these platforms. We really have just the vaguest and least complete information about what their moderation standards are, what their algorithms are, and we should have freedom to opt in. I mean, that it should be our choice to opt in to various algorithmic feeds. There should be complete interoperability, which means that third-party software could be attached. We could choose whatever filtering approach we wanted through some third party. In other words, we would choose our own algorithms. So those are the alternatives to heavy-handed government restriction, which unfortunately the heavy-handed government restriction seems to be the way that many countries are moving.
Mm-hmm. So as a follow-up to that, what's your view on the role of state-funded media in the marketplace of ideas?
Yeah, I think that's a really interesting question and very pertinent in the U.S. now, as our state-funded media, the Corporation for Public Broadcasting and National Public Radio, both of which I enthusiastically support with limitations. It has been completely defunded by the Trump administration for some reasons I understand, because I'm mostly a radio listener, and I can say that NPR, and I've heard the same thing about CBC, has very much gravitated to the left and is not necessarily giving complete and fair coverage of certain controversial issues, and that's annoying to taxpayers. So it's kind of a conundrum. With government funding does come power to defund or if the media do not adhere to certain policies that are favorable to the government.
Sure.
So isn't it a recipe for either complete independence, which is like putting a thumb in the nose of taxpayers who have a different point of view, or at the other extreme, to just becoming a mouthpiece for whatever percentage of the population wields political power, which isn't very desirable either? I don't really have a good answer to that, other than it would be wonderful to, again, let a thousand flowers bloom. In the United States, I'll say this, that again, I'm mostly a radio listener, and everywhere I am, when I'm traveling constantly, I listen to the local NPR affiliate, and there's much more a variety and diversity of viewpoint and perspective. So maybe if we could encourage, not centralized government funding, but local government funding with an emphasis on encouraging viewpoint diversity.
Yeah, great. One thing that our academic freedom policies across campuses in Canada tend to emphasize is the importance of notice. You know, if there's going to be triggering content, for example, or if a course is mandatory, you know, then the people coming have a right to choose whether or not they want to be there. How this fits into the larger arc of material.
And it's really positive, despite when the word trigger warning first entered our vocabulary in the United States, it was something that some people were advocating as mandatory, that professors had to give trigger warnings about any material that might cause an adverse psychological or emotional reaction on the part of students. That is problematic because that really limits academic freedom, among other things. And I've read a lot of meta-studies by psychological experts who say it's actually not good for the mental health of the people that you're trying to protect. It's one of those things that may make you feel good, but it's not necessarily of great therapeutic value. But of course, consistent with freedom of speech and the academic freedom of faculty members, of course, they should be free to provide whatever warnings they think are salutary. And, you know, it's in some cases a delicate balance we have to make, as with everything we do in teaching, right? Kristen, we want to be effective communicators and educators to our students. And who knows, if you give a warning about a certain subject or topic or opinion, that may be like putting a scarlet letter on it. It may be, in that sense, seen as discriminatory in some way toward the content of that material. On the other hand, what maybe by warning students in advance, it will help them to be prepared to encounter what would be difficult materials.
Let me go to another question from the audience. You wrote in your 9/11 essay in 2003, it would be tragic if we let the terrorists terrorize us into abandoning the very values that they have attacked. However, since then, we have seen a lot of collective traumas in our society. And so the question is, what's the right remedy for this ongoing problem, and what's causing the movement in Western countries to restrict freedom of speech?
Excellent question. And as happened after 9/11, as has happened throughout history and around the world, a response to any actual or feared danger to the society, an instinctive reaction is to repress rights. Don't take my word for it. My friend and colleague Jakob Michangama, I mentioned him, the founder of the Future of Free Expression, wrote a book about 5 or so years ago, a thick book, but there's also a podcast version of it for those of you who prefer a shorter version, called A Global History of Free Speech from Socrates to Social Media. And he really does apply the same principles. And you can see in every culture, in every period of history, with every form of government, every ethnicity, every religion, you name it, there is a consistent pattern, number one, of individuals who have an instinctive desire for free speech, to express themselves, to communicate with others, to participate in the political system of the community. And there is simultaneously pressure against free speech as a danger to whatever is the feared value, or let me say, posing whatever danger is the most feared. So I think there was, after 9/11, there was an understandable desire to do something to prevent another similar terrorist attack in the United States. But before there was any examination of what caused this terrible failure of national security, Congress rushed through with almost no hearings, almost no debate, something called the USA Patriot Act. It was a long-winded acronym for, a lot of words, but who could vote against something with that name? Cracking down on civil liberties, free speech, on privacy, preeminently rights of immigrants also. And there was no attempt to explain why any of these restrictions would result in any increased security. But Congress felt we have to do something. And scapegoating civil liberties is something that is not politically costly, especially when the civil liberties that are cracked down on are those of an embattled, unpopular minority. So even before the Patriot Act was rushed through several weeks after 9/11, the immediate response was what the Justice Department itself later admitted was a haphazard and arbitrary sweeping roundup and imprisonment of hundreds of young immigrant Muslim men from North Africa or the Middle East. They were held in incommunicado detention. Lawyers, including from the ACLU, couldn't even get access to them. And why? It was guilt by association. This was the demographic profile of those who had attacked the United States. And there was such huge public support for that. And there's a double wrong there, Kristen, because not only are you violating the most basic human rights of everybody, but particularly targeting certain minority groups, but you're also not doing the investigation and taking the steps that would actually meaningfully protect against terrorist attack. It's a diversion from finding the real solutions. So since the questioner asked about 9/11, 3 to 5 years after the attacks, there was a bipartisan commission that was appointed to do a deep dive into what the actual causes were of the terrorist attacks, the actual security flaws, and not a single one had to do with too much free speech, too much privacy, too little government surveillance power. And they put out a list of something like 12 recommendations of steps government should take, some of which were very mundane, like upgrade your computer systems. The FBI had very outmoded computers, or communications ability within the New York Police Department, the most basic stuff. And a year later, after that report came out, there was an assessment of what government had done to take those steps, and they got F grades on just about every single one. It's so much easier to scapegoat civil liberties. You don't have to raise taxes to do that, right?
So thank you very much for these really rich ideas, and I'm delighted to have had this opportunity to engage with you. Thank you for listening to this episode of Jurist Conversations in Law. I hope you found this discussion with Professor Nadine Strossen as thought-provoking as I did. Her reflections remind us that freedom of expression is not a static principle. It's something that must be examined, defended, and practiced within the context of a continually changing society. As we've heard today, the challenges facing free speech are complex and often deeply intertwined with other values. They underscore the importance of legal education, critical thinking, and respectful engagement, especially for those preparing to enter the legal profession. At the University of Ottawa's Faculty of Law, we are committed to fostering exactly these kinds of conversations, ones that encourage diverse principles, rigorous debate, and a deep understanding of the law's role in advancing justice. If you enjoyed this episode, we invite you to subscribe to Jurist Conversations in Law and to share it with your networks. I'm Kristen Boon. Thanks for listening.